Oh, it's my favorite type of story. Real gritty news ripped from the headlines. True crime. Story of Nancy Crampton Brophy. 71-year-old romance novelist. Has authored nearly a dozen books, but it is a blog post from 2011 titled, I kid you not, How to Murder Your Husband, that is now turning heads. Now, over a decade after penning that blog post. Brophy is on trial for, get this, you'll never believe it, the murder of her 63-year-old husband. But the blog post has been excluded from the trial. This is something, Jack McCoy would be outraged. And let's find out what a criminal defense lawyer thinks about this. And our legal analyst, Ari Goldkind's on the line. Ari, I saw this story, and I said to myself, I need to talk to you about it. Welcome to the show. Oh, do we have Ari?
You sure do.
Oh, there he is.
I was just enjoying the Law and Order music.
Oh, let me tell you something, Ari. No problem. We're going to cut that out in editing for sure. Now, Ari, talk to me here. When you saw this story out of Portland, Oregon, what do you think?
I can tell you two things. One, Jack McCoy, I don't think would necessarily argue to have this come in because Jack McCoy knows the law. So here's the reason why most people listening will say, of course it should go in. It shows that she's a killer. It shows that she planned it. Why wouldn't the jury have it? Here's the contest of why it doesn't go in. Is the probative value, and I'll explain what that means in English in a moment, is the probative value, does it outweigh the prejudice of putting it in? Or does the prejudice of putting it in outweigh the probative value? And here's what that means in simple English. You put that in, and the jury is going to convict her because they're going to say she's been planning this for 8-9 years. It's a hump she can't get over. The reason that the prejudice is so high is because we want to convict people for what they actually did, what the evidence shows they did on the day of the murder, any motive. Unless there's a hallmark here, and I'll give you an example that's well known in Canadian law. Let's say, and I'm going to be very serious, there's a killer or rapist who at every murder scene leaves a bottle of orange juice, Tropicana orange juice, 1 liter of it, okay? That's what's known as a tell or a hallmark or a signature that allows an application to be brought to say this has the unique identifying fingerprint hallmark of a specific kind of killer or rapist. The fact that she wrote a blog, okay, is not, to me, connected with the fact that this is the evidence that can be used to show he killed them. Now, people will raise an eyebrow and say, why not? And I can explain why that is if you'd like.
Okay, tell me why not. First things first, though, I want to tell our audience about the victim here, okay? So for everyone listening, Chef Daniel Brophy found dead inside the Oregon Culinary Institute. This is a Law and Order show, by the way. Just imagine him being discovered. Inside the Oregon Culinary Institute in 2018 as students arrived for their classes. We're now 4 years after the death. Everyone's looking at this story. It's such a true crime thing. Go ahead, Ari.
Okay. So she's on a blog years and years earlier saying something that probably a lot of wives have said about their husbands, maybe even vice versa. She's also a writer, okay? She's allowed to blog her thoughts. This is an issue often in Canada about rap lyrics. You may be familiar with that, where rap lyrics say, I'm going to shoot you dead, and there's all sorts of applications, usually unsuccessful, to get those rap lyrics before the court to show that the guy's a killer or thinking about killing or a gangster. If she had, now this is the key, Elias, for the audience who goes, well, if she said it, this should go before the jury because it shows she's a bad person. We don't convict people on writing bad thoughts or being creative or being fictional. Here's where it should go in, Elias, and I don't have evidence or information that the following of what I'm about to tell you isn't. Mm-hmm. If in 2012 she said, here's how to kill your lousy husband in 22 steps, okay?
Yeah.
And the scene, the murder scene, the crime scene, had 21 out of 22 of those steps. You follow what I'm saying?
Yeah.
At that point, you can be rest assured that that blog is going in. But basically writing about how to kill your husband, I want to kill my husband, here's where you go buy a gun. Well, if you know anything about the United States, what percentage of people in certain U.S. states possess and own a gun in their home. So that's of no argument to me. So the real piece here for people who wonder, why wouldn't this go in? Because clearly the jury's going to see she's killing-minded. That's the exact kind of danger that criminal lawyers live and breathe to prevent. And by the way, if the Crown or the prosecutor in the States can't prove the case without that blog, it's a pretty lousy murder case against her in the beginning, even though, Elias, you may say back to me, and many of your listeners would as well, it's usually the domestic partner in a homicide that is the first person responsible or the police look at. So there's that hump to get over. But the 21 out of 22 steps, if she's blogging essentially a how-to manual, at that point, the prosecution application to get it in becomes much, much stronger rather than works of fiction in somebody's mind 7 years earlier.
So how do you think courts usually rule in this kind of affair? Do you think the courts do a good job of excluding stuff that would taint the jury's thinking here, or do you find it's the opposite usually?
I think, well, it depends on whether you're a criminal defense lawyer, a prosecutor, or an ordinary average citizen.
Yeah.
You know, and really, like, you know, I have my bias given what I do for a living, but people who know what I do for a living in my media role know I try and play it down the center and, you know, don't drink any of the Kool-Aid of either side. So the answer is, courts really do bend over backwards in Canada to exclude, to kick away what they believe to be prejudicial evidence. For example, there have been cases where a murderer charged with murder has teardrop tattoos under his eyes, okay? Which, if you know in certain culture or gangland culture, means, you know, a body. You keep the mark of a body. Courts bend over backwards and make crowns work very hard to get this stuff in. And a lot of the time, and you'll see this after big cases, even in Montreal, you'll see after the jury has given a verdict, you will see the local newspapers or TV channels light up with, here's all the things the jury didn't hear because the judge kept it from the jury because it would be too inflammatory or prejudicial. So that's something that if any of your listeners think about the big cases of the last 2 or 3 years, there's almost always an autopsy report in the news, pun semi-intended, of all the things the jury didn't hear. And that, to me, is the best way I can answer your question, which is we still have a rule of law in this country. As much as certain people in certain groups want somebody, as soon as they're accused of a crime, to be convicted of it, why bother with the trial? Okay, let me give you my dumb Jack McCoy line. I got 30 seconds to wrap up here line. This is a dumb Jack McCoy in a scene from Law & Order, and I'm in front of the judge. I'm like, but, Your Honor, it speaks to motive. And what does the judge say to me? Oh, the judge will say that motive doesn't have to be proven by the Crown. Absence of motive, there's all sorts of language on motive. We can't do it in 30 seconds.
Yeah.
It does speak to motive, you're right, but it's so prejudicial on the jury's mind that they're going to think she's been planning to kill him for 7-8 years without really serious evidence about it. And as I said, without the 21 out of 22 steps that would then make that blog post, to me, much, much more important versus prejudicial. How
to Murder Your Husband, the 2011 blog post of Nancy Brompton Brophy, on trial right now in Portland, Oregon. Ari, you were the right guy to talk to. I'm so happy you came on. Thanks so much.
Good to talk.